Hello, everybody. This is Fred Eckert with Chicago Title. 2 days ago, I was asked a question from one of the realtor clients I have. She had a client that said he wanted to add his son onto the title to his property, and what form, meaning what kind of document would you use for that? So the simple answer to that is you'd use a quitclaim deed, typically. You could use a grant deed too. Typically, a quitclaim deed would do it. However, I felt remiss in not saying and asking these questions that I thought she should ask her client before she recommended just giving him this form. And these are some of the questions. What was the reason that he wanted to add the son onto the title of the property? What was the age of the son? Was the son of age? In other words, you wouldn't want to add somebody to your property that was underage, because then you'd have a problem trying to sell or refinance without having a conservator, if you would, look after, even though it's your own son, look after their interests. Is the son married or contemplating getting married? Does the son have any debts or liens or suits or judgments that might impact that property? The other thing would be, do you get along well with your son? What would happen if, for say, you and your son didn't get along for some reason, had an argument, and he's on the title to the property, and you want to refinance or sell, and he doesn't want to? I also think these kinds of questions you need to think about very, very carefully before you add someone to the title of your property. There's other devices that you can do to do that. You can use a revocable transfer on death deed if you were in California. In this case, I said you should also find out, does the man have a trust? Because he could have clearly accomplished that same thing by creating a trust or having, in the trust, giving that property to his son. I mentioned the part about whether the son was getting married, and apparently he was. And I thought, well, does the father then know that the property that he gives his son will be, in California at least, community property, unless there's a separate deed that the wife signs off on, or future wife signs off on, that says it's not her property. And again, the comment I make is that could cause some issues if, you're getting married and you say, well, I don't trust you to have half of this property, so I'm going to, you're going to sign this deed and make sure that it's just mine solely. And that may be an appropriate thing to do. Don't get me wrong. However, it could cause some stress in that relationship. So I'm available anytime, evenings and weekends included. You can call me if you have questions about, if you're thinking about adding something to the title, if you're thinking about refinancing or buying or selling, or if you're thinking about trying to flip a property, whether it's right for you. I can help in all those things. I'll be happy to give you my advice. And a lot of times it will be, maybe don't do what you're thinking about doing. Sometimes it will. But I think I'll give you the best use of my time and my knowledge. I've been with Chicago Title for 25 years. I was in the Navy for 22 years. I was a legal officer, worked for Dun & Bradstreet, got a master's degree in business. So I really can help you with things and be happy to give you free advice. No questions asked. So make it a great day. Again, my number is 619-507-5688. And the email is Eckert, ECKERTF, @ctt.com. Make it a great day.